Hi, everyone. Thank you so much for the invitation. I'm really happy to be here. This is a very important event, and we're always very happy working with the Institute. We've worked on several projects together, and it's always really great to work with all of you. Yesterday, there was a huge, what do you call it? I've got the Greek word. Strike across my country, and I wasn't sure I was going to be here, and then I came here, and finally I'm here, and I'm happy. And I'm going to talk to you about hate speech and the European Court of Human Rights. I think it's very important for me to set a disclaimer at the very beginning of my presentation, in that free speech is about democracy, and free speech is about free speech, and that's where we must put the full stop. We're increasingly seeing the weaponization of the discussion on free speech by the left, the right, whatever those terms may mean. We see the weaponization of free speech by political parties, politicians, civil society. That's not what it's about, right? And when I do criticize the Strasbourg court intensely in my work, that does not mean that I don't believe in the system that exists. So I think it's really important to take a few moments to really consider that aspect. Now, so I'm basically going to guide you through quite a few of the important cases of freedom of hate speech before the European Court of Human Rights, and try and identify some of the key challenges that I think exists in terms of the way the court handles hate speech cases before it, and the dangers that brings to freedom of expression. And at the end of the day, the European Court of Human Rights is something that connects the Council of Europe countries, is a court which is important, is a court that we need to look at, and is a court that we mustn't ignore, neither the court nor its judgments. So the first thing that I want to kind of raise is, what do we mean by hate speech? I'm not going to go into a philosophical discussion, but a little bit more in terms of where do we see it? Do we see it defined in any of the legislation? Do we see it defined in any of the international instruments? Do we see it defined somewhere coherently and that the court, for example, might use? My answer would be essentially no. The closest we have on a kind of international level, which would be at a United Nations level, is Article 20 of the International Covenant on Civil and Political Rights, which prohibits the advocacy of discrimination and hatred against religious or racial groups. I'm going to make a point here. I'm not just going to read through the different kind of definitions. There's a kind of point I want to make. Then we have the very famous or infamous Digital Services Act. I personally am not a great fan. I understand the role and the structure and the infrastructure that it's meant to provide, but I think there are many dangers with this new DSA of the European Union. It kind of freaks me out a little bit. And this DSA kind of says that online platforms have this obligation to remove without undue delay inter alia illegal hate speech. But it doesn't actually say what that means, right? What are we talking about here? Let's not all forget that we're actually talking about speech, okay? And then we have the framework decision, again, an instrument of the European Union, and that kind of deals with the criminalization of certain kinds of speech. There we do have some kind of nuance in terms of what this could include. Again, there is a focus on speech directed at racial and religious groups, and also revisionist speech and denial of some genocides. In all these instruments, on an EU and UN level, when we do see a kind of extrapolation on what hate speech can be, we always see it interlinked with racial and religious groups. We never see, for example, one of these instruments dealing with homophobic speech or transphobic speech or any other kind of speech that could be considered hate speech. And that's where the great professor Eugene Volokh comes and says, well, what happens here is a kind of minority envy. So if I am a victim of hate speech, but the law doesn't protect me, and you are a victim of hate speech, but the law does protect your protected characteristic, then it creates some kind of tension. So we have to be very, very careful in terms of what these kind of laws and subsequently the case law can kind of create. It can also create some kind of tension between groups that experience similar phenomena. So very simply put, we don't actually have an agreed upon definition or understanding of hate speech. That doesn't necessarily mean it's a bad thing. That's probably a very difficult thing, to happen. But what we do see is a consistent prohibition of speech that targets racial and religious groups, but no other groups. This is on a UN, EU level. This is a Rabat Plan of Action. Why am I mentioning this? It's a UN document, but it's often referred to in case law of the European Court of Human Rights. And it kind of has a 6-part test. I'm not going to go into too many details. I mean, you can read about it also on your own in terms of, okay, when do we identify that hate speech exists? And it has this 6-part test. For example, what's the content, who is the speaker, the intent, etc. And sometimes the European Court of Human Rights very fleetingly refers to this Rabat Plan of Action. Now, digital considerations. One of the things that I do say in the book is that it's not just the jurisprudential analysis of hate speech cases. I think the European Court of Human Rights could take a very pioneering position in terms of dealing with hate speech. And it is looked at, I mean, if you read cases of the Oversight Board, for example, of Meta, there are references to case law, several references to case law of the European Court of Human Rights. When IT companies are developing policies, they do turn and look at jurisprudence of Strasbourg. So Strasbourg really needs to kind of step up the game and protect free speech, because that's what it promised to do in 1976. I'm going to go back and forth in a minute. Most of those slides are about Eric, so just read his book. But I'll get back to that. I want to get to, yeah. In 1976, the European Court of Human Rights very clearly said that speech extends to ideas that shock, offend, and disturb. That was not a hate speech case, but that's the framework it set for freedom of expression, right? But since then, we've kind of seen a deterioration of the way freedom of expression is protected by the European Human Rights Court. Just the other day, it was yesterday, we had a case where the European Court of Human Rights said that if a country doesn't investigate allegations of hate speech, then this gives rise to a breach of Article 8, the right to privacy and family life. So we're now creating a positive obligation in terms of how to deal with hate speech. So this is a kind of overview. Article 10 of the European Convention on Human Rights says we've got free speech, but it's not absolute. There are some limitations. The 1976 case of Handyside versus the UK said free speech extends to ideas that shock, offend, or disturb. And then we have this other article that we're going to have to discuss today, is Article 17, which is the prohibition of those who want, like, the abuse of rights within the convention. So if I wanted to take a convention right, for example, the right to free speech, and abuse it in order to destroy the rights of others, then that's not allowed. And we see that case almost systematically being used in Holocaust denial cases. But only the Holocaust, because in a case which involved another genocide, which we'll discuss in a minute, Article 17 wasn't used. So we do see a kind of hierarchy in what the case considers this kind of speech is worse than the other. So, and let's not forget, this is the regional human rights court. It's a little bit tricky when those kind of things happen. So the first kind of framework I draw is what I call the low threshold hatred cases. These are a set of cases involving politicians I wouldn't give them another thought, to be honest. I don't agree with anything that Ferrer says. This is a Belgian politician. He was the leader of a political party in Belgium, and he was part of his political kind of manifesto, and for his election, he was going on about let's prevent the conquering of Belgium by Islam. He was saying about a refugee center in a particular neighborhood, that it was destroying the kind of neighborhood, and this kind of rhetoric, which at the end of the day is political rhetoric, and if he wants it as part of his political manifesto, the court itself says that we can have ideas that shock, offend, or disturb. He wasn't calling for anyone to be violent against Muslims. He wasn't calling anyone to go and be violent against the refugees in the refugee center. And none of this was online. It's very important to distinguish the online and offline elements of hate speech, which is another subject, but it's very, very important. So Ferrer, typical kind of rhetoric that we very often see, and he was banned from office running for office for 10 years. He got a criminal sanction, and he went to the European Court of Human Rights and said, I thought I had the right to freedom of expression. I thought that was part of the way democracy works. And that's when the European Court of Human Rights started to develop this kind of low threshold hatred paradigm. It said, okay, no, you don't have the right to freedom of expression, and characteristically said, inciting hatred does not necessarily involve an explicit call for an attack of violence or other criminal acts. Attack on persons committed by insulting, holding up to ridicule, or slandering specific groups of the population can be sufficient for the authorities to favor combating xenophobic or otherwise discriminatory speech in the face of freedom of expression exercised in an irresponsible manner. So I've read that out. I'm not going to read stuff out again. But this is a major turning point of the European Court of Human Rights in terms of how it dealt with this kind of speech within the political sphere. And what we've seen is since Ferrer, which came out in 2008, we just see the European Court of Human Rights replicating this idea, which it's basically coming and saying, if you say something and it's a little bit slanderous, or some people might be offended, or some people may feel that they're ridiculed, that's not freedom of expression. Even though we have other case law where it says that political speech is very, very much protected speech. Now, again, I would not vote, if I was a Belgian person, I would not vote for Ferrer. He was always complaining about things, never had solutions, typical kind of populist approach, but he was part of the political system. He was part of a political party that was registered within the state and whatever else. And he never targeted Muslims. This is very, very important. He never targeted Muslims. He was saying that Islam and the ideology of Islam is conquering Belgium. Again, I wouldn't adhere to his position, but I would definitely understand that he has the right to express that to get his votes and whatever his ideology may be. But the court didn't agree. And there's a great dissenting opinion in this case where Judge, okay, I'm not in Hungary, but you probably know how to pronounce this better. Someone please, Judge S-A-J-O, Eric, how do we say that? Sajo, okay, so the Hungarian judge at the time often had excellent dissenting opinions. He says, okay, this is my own kind of translation from French. He's like, the court is treating the people who vote as nitwits, that they can't think for themselves, that they need protection from offensive speech, because part of the Ferrer decision was like, oh, we need to be really careful because some uninformed members of the public might be affected by what Ferrer says and suddenly become very racist, suddenly become very Islamophobic and run to vote for Ferrer. And it was very, very interesting how the court referred to the uninformed members of society. So what has the court itself done? It's divided people of Belgium or whatever other country into the stupid ones and the smart ones, or it's like, Why do that? So I don't like this case very much. And I do see this case kind of developing into other things. So that's a kind of fairer case. And then we go to the aftermath of Ferre. Valand versus Sweden. Another group of nitwits, crazy people. It was a youth group, crazy for my opinions, might not be for yours, and that's the beauty of democracy, right? So it was a youth group in Sweden, and they were making these leaflets. And in these leaflets, they would say, oh, gay people, it's their fault that there is AIDS. Gay people, they're the reason for pedophilia. They're the ones who are disgusting, and different words, right? I'm giving you the facts very briefly, otherwise it gets very, very tiring. And they printed out these leaflets, and they went to high school. And when the kids were in the lessons, they would leave the leaflets in the lockers. And they got in trouble, and they got... And by the way, in Ferre, as with in this case in Sweden, we're talking about criminal penalties. Okay, this is very important. We're talking about the imposition of criminal law on offensive speech, right? I just want to clarify that. Again, none of these leaflets were saying, pick up your arms or whatever, pick up your weapons and fight the gays or anything like that. No. And they went through court in Sweden, they received penalties, and they went to the European Court of Human Rights, Valand and others, some other ones of the group, and they said to the court, but this is our freedom of expression. And the court's like, no, you were being prejudicial. You're not allowed to have those express those opinions. They are prejudicial to the gay community. And there was the argument that, there was no incitement of violence or whatever. And in Valand, they basically copy-pasted what they said in Ferre. And they said, this is prejudicial. It's not very nice. It's unkind. So that's not free speech. Right? And then we get to Liljendahl versus Iceland. This is even more odd for me. There was a newspaper article, and in Iceland, there was a discussion of a new educational program in high schools for supporting students who were transitioning, so transgender students, pupils in the schools. And it was like how to support transgender kids and things like that. And this random guy that no one knows, not a politician, wasn't a youth group, wasn't anyone, just a guy called Liljendahl, wrote a comment under the newspaper article saying, oh, this stuff is like sick, it's abominable, kind of different words to describe how disgusting trans people are. But in his opinion, but again, not calling for any violence. And I'm sure that no one would have noticed his comment anyhow. I mean, he was just a random guy commenting, and he got into trouble in Iceland. Again, it was a criminal trial, and he went to the European Court of Human Rights, and he's like, but it's my freedom of expression. And the court was like, no, it's not. You can't hold that expression. And the imposition of a criminal, sorry, I don't know if you can hear me, yeah. The imposition of a penalty and a fine is proportionate and necessary in any democratic society because your speech was offensive. And we're talking about a comment under an online kind of article in the newspaper. Now, there's a very big problem here, in my opinion. Something that I don't need to discuss further, I mean, that's not what freedom of expression is. B, and what worries me most, and this is something we see a lot, I see a lot in my research, I don't like reading homophobic comments. They upset me. I don't like racism. I don't like homophobia. I don't like any of these things. They definitely upset me, right? But when we impose criminal penalties, and we have the highest human rights court of the European region coming and saying, you're not allowed to believe that, we are giving a platform, because the platform given to Lilian Dahl after the Strasbourg decision, the way that that decision was weaponized, gave it such otherwise no one, maybe 5 or 10 people would have seen his comments. And you're creating this situation whereby people who do have what I would consider hateful opinions, a platform, right? So the court, in my opinion, needs to be very, very careful in terms of looking at the consequences. What happens when it contributes to the silencing even of those opinions that they consider to be offensive? So this is the kind of first bunch of cases that they're not all here, I mean, that I kind of bring together in my research, the low threshold hatred paradigm, where the court is basically ignoring its 1976 Handyside decision and says, if speech is offensive, it may not be allowed. And in none of the cases did it allow for freedom of expression. So we're closing that chapter. I hope I've made it clear. And I want to add something to this, and this is quite important. We've seen the court sometimes being a little bit confused by what it means by offense. So I have a case here, 2 cases that I want to compare. The first case is the case of Ibragimov. This was a case which involved the banning of a book by a Muslim scholar on the ground, in Russia, sorry, it's not there, on the grounds that it was extreme. It was extremist and it was, etc. It was extremist literature. And the book was banned, and the publisher of the book went to the European Court of Human Rights and said, but, you know, it's freedom of expression, it's a book, it's published by this scholar, blah, blah, blah. And here, and I'm going to read it because it's very important, the court said, merely because a remark may be perceived as offensive or insulting by particular individuals or groups does not mean that it constitutes hate speech. Yeah, I agree. But why didn't we say that in Ferre, in Veerland, in Lilian Dahl? Give us some certainty, you know? Explain to us what you actually understand by offense. So when it came to the banning of a book by a Muslim scholar, they're like, oh, but even if you're offended by that, that's free speech. Agreed. I think we're probably all going to agree on that, right? But we need some consistency. Because in the other cases, you said to us, oh, but if it's offensive, it's not free speech. And then if you directly compare Ibrahim with Atamanchuk, this case concerned statements made by this guy, a journalist and a politician, that non-Russian people, this is again a case against Russia, and then he had described non-Russians as, you know, they're involved in criminal activities, and, you know, they're causing social unrest, and, you know, the typical thing that we hear people saying about people who aren't from our country. I hear that a lot back home. Anyone who's not Cypriot is a criminal. Is this being recorded? Anyway, certain groups. And there the court's like, no, that's offensive. You're not allowed to insult people like that. But in Atamanchuk, you said I'm allowed to offend people. So do you see what I mean? It's a kind of double standard. And I think the Strasbourg court has to be very consistent. I think that's important. Yes. And then the court comes and says, so we have hate speech which is uttered by the people who are speaking. So Ferez, the politician, Lilian Dahl, that random guy typing the comments, and Veerland, that youth party. And then we get to third party liability. So it's the case of Delphi versus Estonia. Very important case. It was the first kind of case which set this kind of third party liability. I'm not going to go through the facts because they're very, very complicated. And I'll just tell you briefly. There was a news article, it was something about some roads in Estonia and when the ice comes and things like that. And there was some derogatory comments about, that were considered hate speech about someone involved in these roads or the building of these roads or the company for the maintenance, whatever. And they were considered to be hate speech. And not the article, some comments below. And this case reached the European Court of Human Rights, and Delphi is a kind of published, it's a platform, right? So the newspaper had published something, and the hate speech was in the comments below. And the European Court of Human Rights said, oh, no, that's hate speech, and again, not inciting violence. And to be honest, I've been working on hate speech for many years, and I still didn't understand where the hate speech was in this case. I have to be very frank with you. I really didn't get it. I'm still trying to get it. And the European Court of Human Rights said, oh, Delphi, because Delphi removed the comments, but you were too late. So the criminal penalty imposed on you, the fine, again, we're talking about criminal law, by the way, in all these cases, was reasonable because you had the duty to very quickly remove this online comment. And that's when third-party liability essentially was born in, by the European Court of Human Rights, basically saying that even, let's say you have an online platform, you're the online platform and hate speech comes from somebody else, you're responsible for the comments below. Now, when we're talking about this kind of speech though, if I didn't really understand where the hate speech is, then we're definitely not that I mean, someone who's involved in dealing with hate speech for many years, I don't really see where it is. We're definitely not talking about incitement to any kind of unrest or violence. The MTU case is a little bit promising, very similar to Delphi, but because MTU, it's a case against Hungary, is a very, very small newspaper, the court said no, they didn't have the resources to be able to deal with removing online comments. That was hopeful. But then Sanchez came along, ooh la la, a case against France, politician from the same party family like Ferrer, and Sanchez, there was a comment under a post of his about how Muslims have made, or immigrants and Muslims have made these different areas of France like ghettos, and you know, we all know how these kind of, this rhetoric works, right? And it's ghettos, and there's criminality, and they're selling drugs, and blah, blah, blah. He didn't write this, it was a comment. And Sanchez actually said, he wrote a post, he said, can we please be civil? Can we not have like racist stuff under my posts? There's actually him writing that. But he didn't delete the post. And he got in trouble. Again, we're talking about criminal law. And he goes to European Court of Human Rights. And he's like, I told them to behave. I didn't say anything racist or Islamophobic, and I still got a fine. And the court's like, yeah, and so that's the right, you know, that's good. And the court's like, yeah, you had the responsibility to swiftly kind of remove that comment. So what we're doing here is transcending from the imposition of liability from Delphi, which is this online platform, to an individual. That individual, yes, is a politician, so it's a public figure. It's not like me having a hate speech under one of my posts. But it's still an individual. It's not a big company with resources or whatever. Not that I agree with Delphi. So you see how things deteriorate over time in terms of free speech. I think that's basically what I'm trying to tell you today. And I'm gonna go to my next subject, but I want to close this part about, you know, the more offensive, insulting, and prejudicial speech, plus the imposition of third-party liability on online platforms and on individuals. We don't have a case yet where there's been just a random individual not removing hate speech, but I hope in that kind of case, because Sanchez was a politician. That's not justifying anything, but that's what the court used. So I wonder what would happen if it was just a comment under the post of an individual who's not a public figure, but I don't have a case to give you for that. All right, and now we go to historical memory and authoritarianism. And here we have some interesting conflicting approaches. We have the case of Perinçek versus Turkey, and it was this guy, it's always guys, going to, I'm sure I'm allowed a bit of sexist speech in the democracy, okay. Perinçek, so it was a Turkish politician, and he had said, he was in Switzerland for an event, and he said, oh, that there's no such thing as the Armenian genocide is a lie, right? And he got in trouble with the Swiss authorities, again, with the criminal route, and he went to the European Court of Human Rights, and he's like, but this is my freedom of expression. That case is very important, and I'll tell you why. The outcome is not great, but it's the only case that I can come and tell you, you know what? The court has really done a good job of analysis and assessment. It actually spent time analyzing the issues. It didn't just say, oh no, this is offensive, so it's not good. Because in none of the cases I told you before, does the court ever actually explain why hate speech should have been prohibited? It never engages with empirical research on the dangers of limiting that hate speech. It never engages too much with any kind of data that can kind of support its positions on hate speech. It sees offensive speech against minority, I don't like that word, but using what is used, minority groups, and they just like say, yeah, we don't want that. But they never actually explain why. They never back up their position with proper empirical or theoretical research, right? In this case, it actually conducted an analysis. And what Switzerland came and said, it said, in all the cases you have on revisionism, on the denial of the Holocaust, you just kick the case out on the grounds of Article 17, the one I told you at the beginning, where you're not allowed to use a human right to destroy the rights of others. And when we have cases involving the denial of the Holocaust, usually you just kick these cases out using Article 17, because when you apply Article 17, you don't have to conduct a legal test under Article 10. I don't want to get technical, but it's very dismissive, Article 17. You just kind of get rid of the case. And we see that in the cases involving the denial of the Holocaust. So Switzerland was like, just do what you always do. And the court's like, no, I'm not going to do what I always do, because the Armenian genocide happened in another country, or what is defined as the Armenian genocide. It was during the Ottoman Empire, many years ago, and nothing to do with Switzerland. So there's no real problem here. And we're talking about another time, another place. There's not really an issue. And there's no general consensus whether the Armenian genocide occurred. So there's two issues here. If I want to do a proper contextual analysis of whether or not I need to be dealing with a case under Article 10, I need to do that throughout all cases. I can't just do it in Perinçek and no other cases. Do you see what I'm trying to say? I mustn't engage in contextual analysis and talk about the Ottoman Empire and that this speech was in Switzerland and blah, 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 and not in Turkey, and there were not many Armenians around, or whatever it was going on about. If I'm going to do that in Perinçek, I need to do that in all cases, right? I think consistency, key. And then the second point is, it's not the job of a court to conduct kind of historical, or construct what historical memory is for a group, is it? I don't think. I mean, it's not its job to come and say, oh, but we don't know about the Armenian genocide because not all countries recognize that it exists. The case in hand was the speech in question, right? So in the Perinček case, at the end of the very long judgment, Article 10 was used. And, okay, the outcome wasn't great because there was no violation of Article 10 found, but it's an interesting case in terms of context. But if you compare, for example, Perinček with other cases like Garudi, or I can tell you several, I'll tell you one. The case of Witsch, W-I-T-Z-S-C-H versus Germany, and it was this guy, he wrote a letter. He put it in an envelope and he posted it. So private letter, not published anywhere, to an academic somewhere in Germany saying, oh, but no, what you say about the Holocaust, it's not like that, and there weren't as many gas chambers, or he was doubting, he was negationist in terms of the Holocaust. By the way, disclaimer, of course the Holocaust happened. This is not what we're talking about here, right? See, I'm getting paranoid as well. Like, when I'm trying, the free speech world has made me paranoid too, in terms of like the message I'm trying to get across. And this is worrying, because I wouldn't have to make all these disclaimers 7 or 8 years ago. So I think that's something to think about. So this guy is not up on the wall, so he writes the letter, sends it to this German professor, and he's like, yeah, the stuff you were saying about the Holocaust, it's not. And this German guy went to the police. And was like, look at this letter I got. He doesn't believe the Holocaust happened. And the police went and got the guy, and they're like, oh, you can't do that. And he got into trouble again with the criminal law. And he went to the European Court of Human Rights, and he was like, but I'm just voicing my opinions in a private letter. And the court's like, no, you're not allowed to do that. It can't happen, right? So that, and then compare that to a public speech in Perinček on the Armenian genocide. You see the doubles, not the difference in approach by the court. I have to cut Strasbourg some slack, because the Council of Europe as an institution was born from the ashes of the Second World War, right? We can't ignore the traumatic impact of the Second World War on our continent. And I can tell you this from experience, individual experience, growing up in a country and living in a country where there has been a war. So I'm Cypriot. I can see how this kind of memory, even though I didn't live through that war, it's embedded in every step of my existence, right? So we need to understand that Strasbourg, as a court, does have a kind of fear of this never again idea of the Second World War and whatever. So I do cut them some slack. But they need, at the end of the day, they're a human rights court, and they need to treat rights equally. So, different treatment between the Armenian genocide and the denial of the Armenian genocide and the denial of the Holocaust. And I give you the case of the private letter just to make a point that, you know, even private letters aren't allowed. And then let's look at symbols. So we're going to let's look at Nix first. All right. So Nix versus Germany. He has a blog, and he was writing his daughter. How long do I have? Okay. His daughter is half German and half, it writes it in the case, I don't remember, not German. And she was having some problems with the labor office in the area they were living, and what he considered to be racist behavior. And he was blogging about it, right? And at one point, he posted an article about her experience that day going to the labor office, basically saying that this German labor office was racist towards his daughter, who was, it was apparent from her appearance that she was, at least one of the parents was from somewhere else, and not Germany. And then he used some pictures from, including like some people from the Nazi party and some Nazi symbols, basically saying, this is the German labor office, they're like the Nazis and they're so racist to my daughter. And he got in trouble for using Nazi stuff, and symbols and people to make his point. And he went to the court and he said, but I was trying to raise awareness on the racism that I know is happening because my daughter is experiencing, and this is my freedom of expression. And the court was like, no, no, you can't do that, and you can't use Nazi symbols. This is a very important case because he was using them to raise awareness on racism, yeah? It's really important. He wasn't a loopy person saying the Holocaust didn't happen, or a racist trying to say that, oh, this and that or the other. So he, the court didn't agree with him, and it didn't consider this to be his right to freedom of expression. But then we go to the case of Faber and Van Eyck. I'm not going to go into them too much. They're two Hungarian cases. One involves the wearing of the red star during a demonstration in Hungary, and one involves the raising of the Arpad flag, like the regime in Hungary, and so one, we have two totalitarian symbols. Let me put it simply. Two totalitarian symbols. Which symbol did they allow and which symbol didn't they allow? They allowed the communist symbol, but they didn't allow the Nazi symbol. In both cases, they got in trouble by the Hungarian authorities, but in the case involving the Communist star, they're like, yeah, but the star's used by the Workers' Party, and okay, communism was bad, but, you know, when you get the but, and things like that. And again, we have the European Court of Human Rights coming and comparing and doing a like kind of hierarchy between totalitarian regimes. I don't get that. And again, I bring back the example of where I'm from. It's a small country. No one cares about us. We had a war, but for us, it's real. For us, I think about it literally in one way or another every day, somehow, in my existence, right? I went to training a couple of weeks ago in Amsterdam, amazing training, organized by a Turkish institution. I've got 5 minutes, yeah. And the way, at one point I got so emotional, like I was crying when we were discussing some issues. For us, it's a reality, even if we're a tiny country. So I don't see how the court can come and, what's the word I'm trying, deconstruct or manipulate, not manipulate, work with everyone's individual realities. You can't do that, right? In the name of free speech. I mean, that's even crazier. So I wanted to say that. Oh, and I wanted to say that there's a plethora of Turkish cases, this is important, and I'll close in a minute, whereby predominantly they involve the PKK, the Turkish Workers' Party. Not now, end of 90s, beginning of the 2000s. And there's even cases whereby someone is actually inciting violence, saying, go and pick up the rock to attack the Turks, and the court actually allows for that free speech. So on the one hand, we have Ferrer, who's obviously a racist bigot and doesn't, you know, who's not allowed to speak because he might offend. And then on the other hand, we have the court allowing for some of the PKK speech, which were actually inciting violence. But that speech wasn't targeting what we would now call protected characteristics, the minority people of the different kind of countries, right? So I think contrasting with the Turkish cases are important. So briefly, bans on Nazi symbols upheld. There's a leniency for communist imagery in the cases. And for me, I know it's an ideological hierarchy. At the end of the day, this is an institution which is very, very representative of the West. I don't think that, I mean, if we had more, I mean, the Eastern, like the judges mostly from Central and Eastern Europe were more reactive to those cases, but it's not about where you're from. the point of the court is to be independent and equal, right? That's basically what I'm trying to say. I'm getting nervous. I'm not going to go through, I'm just going to close up because I don't have much time. So Strasbourg, what does it need to do? It needs to start developing more solid approaches. It needs to start looking at empirical work. It needs to start looking at theoretical work. It needs to start supporting its positions on hate speech much more. And what it is creating is a kind of, what's the word I'm looking for? People not taking them too seriously, right? We don't want courts creating martyrs. We don't want courts kind of giving a framework through which haters can say, look, the mainstream is silencing us. We don't want that, right? So I really think that it's time for Strasbourg to kind of think about free speech again. Thank you very much.
Thank you, Natalie, very much. We have time for 2 quick questions, and I see a gentleman raising his hand over there. Fantastic talk, by the way.
Thank you.
Thank you. I would like to ask you about what do you think the criterion should be for distinguishing the cases? It seems that European Court tried to construe some distinguishing criterion. For example, in judgment Sava Terentiev versus Russia, Court said, I can cite, that unprotected minority or group that has a history of oppression or inequality or that faces deep-rooted prejudices, hostility or discrimination, or that is vulnerable for some other reason, may in principle need a heightened protection from attacks committed by insult, holding up to ridicule, or slander. So it seems that court is trying to distinguish cases like insulting and disturbing, and between defamation of vulnerable groups that can be harmed with this a group defamation. So what do you think about this criterion that court tried to establish?
Do I answer now or wait for the second question?
You are right now, yeah.
Right, okay, that's a great question actually. And I have a piece out today, it's in English, and in German 2 days ago, exactly on this, basically explaining what I consider to be a kind of the court taking a very paternalistic approach to these vulnerable groups, these vulnerable minorities. It really connects to kind of, at the end of the day, it has to be someone's view who is vulnerable and who is not. There are historically oppressed groups that obviously the court kind of doesn't realize because, I mean, how many died under communism, if we think about it, right? So it's not sticking to its word. And when we go down the path of dividing people, it can create also what Volok refers to as kind of minority envy, and it opens a huge framework through which the court and the people making up the court, because at the end, the judges are people, right? To be able to decide who's protected and who's not. And it also creates a systemic imbalance. I'm not ignoring the fact that, like Orwell says, some people are just more equal than others. I think that, we can't ignore that. But when we have a court upholding speech in some cases, so for example, the case of Ibrahimov, but not in others, even when that speech is not even inflammatory speech, then we have a question of free speech. But at the same time, it doesn't mean that I'm just apathetic to the strife that a oppressed group may experience. But what I see from the case law is that it really doesn't deal with the distinction of these groups properly. With the most major thing to compare is the way they deal with Nazism and communism, both things that affected Europe, right? So I think that yes, vulnerable groups don't need protection from a court. I think vulnerable groups need protections from a structure, from a proper functioning democracy, and need to have free speech. That would be my kind of antidote. Because if I'm going to come as a court to paternalistically say, like, my kids, I'm going to protect my kids, right? And I'm obviously going to do that. They're minor and they're vulnerable. But if I don't establish a structure for them to flourish, then they will be weak their whole life. And I think that's the kind of way I see the court. But it doesn't mean that I don't recognize the oppression. I hope I've answered you. It's a long it's a very interesting question. Thank you.
And we have
We're done?
And we have one short question from Carol.
Really short question. This is me, the third-party liability, especially for private people, it's just totally crazy to me. When did it start, like the Sanchez, for example?
2022. 22, yes. There's even more crazier cases for another symposium, I can tell you. Thank you.
We'll be looking forward to it. Thank you once again to Natalie.